Good afternoon, everyone. It is my pleasure to welcome you to the very first installment of SBF Infrastructure Committee webinar. The topic for today is Understanding and Minimizing Impacts of COVID-19 on Singapore's infrastructure sector. Before we proceed further, I would like to touch on some housekeeping issues. Please note that this webinar is meant for general information only and does not contain or convey any legal or other advice. All efforts have been taken to ensure the information provided is accurate as of publication date. Lastly, please note that the authors reserve all rights in the material provided. Moving on, if you have any questions during any segment of the webinar, please utilize the Q&A function. In case we received a lot of questions, we may extend the webinar to 4:15 p.m. We will try our best to answer as many questions as possible, but for the questions that we are unable to answer today, we will work with the panelists and email the responses to the attendees post-webinar. As such, in order for us to attribute the questions to the right attendees, please indicate your name and company in your Zoom ID. For today, we are very honored to have Mr. Sim Chee Siong from Rajah and Tann, Mr. Mien from Allen Gledhill, and Mr. Pek Lian Guan from Tiong Holdings to grace our events. We will be having 3 segments today with 2 presentations of 20 minutes each and a 30 minutes panel discussion with Q&A. Without much further ado, I would like to invite Mr. Sim to start on his presentation. Mr. Sim, please.
Thank you, Jeffrey. I would want to start off with thanking SBF for inviting me to share my thoughts on COVID-19. And I trust that you all would agree that we now live in extraordinary times. COVID-19 has caused significant impact on businesses and on our daily life. As you can see from the slide, WHO has declared COVID-19 outbreak as a pandemic. Whilst COVID-19 has brought about new opportunities for some businesses, for example, food delivery, those that provide online meeting services like Zoom, medical industry, COVID-19 also changed the way we work, we speak, and socialize. Now working from home, CB stands for circuit breaker, Zoom party, all now have become the new normal, even the term new normal. It has also changed the way how we greet each other. Now we greet each other, stay safe, stay healthy. Having said that, this normal has caused disruptions to many industries. And you can see that there are difficulties in procuring materials and plant. Many cities, including in China, were under an unprecedented lockdown. The reopening of factories after Chinese New Year has been delayed. Supply chain has been disrupted. Another difficulty is in relation to the movement of workers to and from China and within the region. And many countries, including our neighbor, has implemented measures to restrict the movement of human beings. For example, Malaysia has imposed their own restriction like movement control orders. The third difficulty lies in the implementing of preventive measures on site. For example, everyday measures such as additional cleaning, temperature checking, filling up of forms, mandatory leave of absence, quarantine order, wearing of masks. All these measures have caused significant impact on business operation. Companies will need to consider their obligation in response to these government measures. The level of business disruption and other commercial risks arising from COVID-19, as well as the options available under the contract. One question which businesses continue to be concerned with is, what are the reliefs under the contract that can be sought? Is COVID-19 a force majeure event, a frustrating event, or simply frustrating? Singapore government has actually introduced a lot of measures to help businesses to tide over this very difficult environment. Whilst measures have been given to help businesses, the government has also introduced other measures to curb the spread of COVID-19 disease. And these measures have a significant impact on how business is done. Notably, is this control order or circuit breaker measures. And these circuit breaker measures started from 7th of April, intended to end on the 4th of May. But what has happened with the increase in the number of COVID-19 cases in Singapore, now it has been extended to 1st of June. Is that the end of the tunnel? These COVID-19 regulations actually not only affect the use of the premises, but also affect the restriction of movement of people. You all would be familiar with essential services. Essential services basically allow those in that sector to continue to operate from their workplace premises. If you are non-essential services, simply you're not allowed to operate from your workplace premises. These essential services can be grouped under 11 categories, but for the audience today, what you are more concerned of is construction. And what are the essential services under the construction sector? Companies involved in epidemic control, construction work in the progress of critical public infrastructure, maintenance and services to ensure public safety, emergency repairs. Selected projects assessed to be in critical stages of construction and are unable to stop due to potential safety risks, and the list goes on. Even if you are essential services, there are conditions upon which you can operate. Essential services providers are allowed to continue to carry on their business, provided that they operate from their permitted premises and they obtain the necessary permission from MTI. And when approving this application, MTI may, depending on the situation, may impose additional conditions and requirements. And even if you are essential services, employers must permit and provide the necessary facility for their workers to work from their place of residence and direct them to do so unless it's not reasonable, practicable to do so. This is what we call commonly as telecommunicating. But really, what is reasonable, practicable? For example, a QS that is supposed to write contractual letters, and then the documents are not stored electronically, but on hard copy that can only be found that are stored on the worksite. Is it reasonable, practicable for them to work from home? For example, a designer who has to cross-reference to drawings, but those drawings are stored on a computer system that is only available in the office. Is it reasonable, practicable for them to log on remotely? So what is this threshold of reasonable, practicable? Safe distancing measures. Essential service providers need to actually ensure that there are safe distancing measures in the work environment. For example, sitting plan. For example, queue, maintaining of 1 meter from each other. Cancellation or postponement of activities requiring in-person interaction. There will be exceptions unless they are critical to operation. For example, site meeting. Are they not critical to site operation? For example, safety briefing. Are they not critical to operation? Having said that, is there any other way to actually have those meetings? For example, through Zoom or through Teams? And if you contravene any of the COVID-19 regulation without reasonable excuse, you can be liable to a fine and or imprisonment. So with the increase in the COVID-19 cases, additional measures have been introduced. And that is from the 10th of April. What are the additional measures? Further safe distancing measure. For example, workers must be grouped and deployed in 2 or more groups. Does this mean that you need to actually double the resources that was originally allocated for the project in order to actually have it in 2 groups? There is also a requirement for staggered working hours. Does that mean that there will be disruption to the work? Does it mean that there is shorter working hours? Will that result in a delay and additional costs? There is also a requirement to ensure a distance of at least 1 meter between 2 individuals. So if there are meetings to be held on site, can your site container office fulfill this requirement? And you can see not only at the activities on site, there are also safety distancing measures traveling from dormitory to site. And the measures is maximum seating capacity for each lorry must maintain 1 meter distance. They must mark out appropriate location. Will this result in delay, in higher cost? Because originally you may be able to ferry a certain number of workers to site in 1 lorry, but however, you can't do so now. In addition, there are measures that have been implemented in relation to clusters and dormitories. And you would know that MOH has actually placed on all migrant workers, work permit holders and S-Pass holders in the construction sector on a mandatory stay-home notice from 20th April to 4th May 2020. Would that be extended? What is the impact on the construction industry where we are heavily reliant on foreign workers? Is there a complete stop for our projects in Singapore? So, with all these challenges, what are the reliefs? Is it to adopt a dual track approach? What I meant by dual track is that Singapore government has introduced numerous measures, one of which is actually the COVID-19 Temporary Measures Act, which Chien will deal with it later on in detail. That act actually changes how business are being conducted. Basically, notwithstanding what is said or written in the contract or other law, this law will take its precedent. And this is to actually help business to survive. And for me, I will deal with the contractual relief. What are the reliefs one can actually solve under the contract? Contractual reliefs. For today's presentation, I will focus on 2 parts due to limitation of time. One is the EOT clause, which is the extension of time clauses, and the other is the force majeure clauses. How to help yourself? So, under many contracts, there are extension of time clauses. For the purposes of my sharing today, I will use the standard form of contract used in Singapore as illustration. And before you is the SIA form of contract. An SIA form of contract actually entitles the contractor to extension of time. However, one needs to fulfill 3 obligations. First, they have taken all reasonable steps to reduce the delay. 2, have complied with the requirements and of clause 23.3, and basically that is a notification requirement for claim of EOT. And the third is that the delay must be caused by one of the events listed in the contract. So you may ask me, what are the events that actually entitles one to extension of time that is relevant to events, to the situation that we are facing now, COVID-19 events? Is it L, which is shortage of labor, not reasonably been foreseen, that at the time of the contract, resulting from domestic or foreign government action, embargoes, or regulation? Or is it M, the shortage of goods and materials which shall not have been foreseen at the time of the contract, resulting from domestic or foreign government action, embargoes, or regulations? And in another standard form of contract commonly found in Singapore, the PSSCOC, which is for the government infrastructure project, there are also power for the employer to grant extension of time. And that extension of time under the PSSCOC form may be extended by the SO, and they can actually, and the extension of time should reasonably reflect the delay in completion of the works. And it must be notwithstanding due diligence and taking of all reasonable steps by the contractor to avoid or reduce such delay. Under the PSSCOC, is COVID-19 event a lockout or embargo causing delay in Singapore? Or is it an event that compliance with the requirement of any law, regulation, bylaw, or public authority? Or is it an event for extension of time whereby it's an instruction by a SO to suspend any works? This term, any law, does this mean that stoppage of production in China mandated under Chinese law will be covered under such clause? What about movement control orders from Malaysia? What about control orders, which I've just shared earlier on in Singapore? Foreign workers not allowed to work. They must actually observe this stay-at-home notice. What if MTI, Ministry of Trade and Industry, allow works to continue on, but the employer wants to suspend works? And even if you can fall under the extension of time clause, please remember in one of the requirements, as I shared earlier on, is basically you must give notice. And this notice must be given in a timely manner. PSSCOC clause 14.3 provides that you shall give this notice in writing and within 60 days. And you must inform the SO, together with the appropriate contract references, of the reason why there will be or may be delayed to the completion of the works, the length of the delay and of the extension of time required, and the effect of the delay on the program. Some of y'all may feedback that this is uncertain time. The difficulty is, where is the light that is end of the tunnel? It used to be the 4th of May. Now it is the 1st of June. Will that be further extension? With a moving target, how can one actually comply with such requirements? To talk about what is the impact of the delay, can one actually provide a tentative rescheduling that is based on the assumptions? Next clause that I will want to touch on is force majeure clause. Force majeure is actually a mechanism under the contract, and the trigger event and the consequence flowing should be stipulated in the contract. And some of my clients ask me, what is force majeure? Clauses meant to deal with. They actually deal with situations that may arise over which parties have little or no control that might impede or obstruct the performance of the contract. And in reviewing a force majeure clause, in a well-drafted force majeure clause, there are usually 5 components. First is the event, the causation, the notice, mitigation, consequences. I'll deal with each one in turn. First one, event. Whether a force majeure situation arises would largely depend on what the parties in their contract have provided for. So in short, look at the force majeure clause itself. And the party seeking to rely on the force majeure clause usually has the burden to show that it falls within the scope and the ambit of that clause. As a matter of illustration, they have replaced force majeure clause with exceptional event. But you can see the concept of force majeure in there. The concept, namely, is beyond a party's control, could not reasonably have been provided against at the time of entering into the contract, could not reasonably have avoided or overcome, not substantially attributable to the other party. So, what is the ambit of the clause that party could not have reasonably provided against before entering into the contract? Is pandemic something that is not foreseeable? What about SARS in 2003? What about H1N1 in 2009? What about MERS? Can COVID-19 be said to be something that is not reasonably foreseeable? And therefore, there are certain clauses, for example, here that you all see in front of you, it is presumed to have established that it is a force majeure event if it is, for example, G, a lockup. Or some clauses actually provide that, pandemic or epidemic is one of the force majeure events. And even if you actually fall under the force majeure event, there is similar requirement for notice, like extension of time, and notice needs to be given for force majeure event. And you can see here, FIDIC 4, the affected party shall give a notice to the other party of such an exceptional event. And there is a time limit. This time is that the notice shall be given within 14 days after the affected party become aware or should have become aware of the exceptional event. So after giving the notice, you still need to prove causation, and you have to show that you have taken steps to mitigate the effect of the force majeure event. And the last part is basically what are the consequences? Because some of the consequences is not what you want to see, and you do want to avoid. You want to avoid the situation whereby you accidentally trigger something, a consequence that you have never intended. Usually, you will find that for force majeure event, you will be relieved from duty to perform the obligation. You will be relieved from liability in damages and contractual remedy for breach of contract, and you will be for the period upon which the event occurs. But for some force majeure event, some force majeure provision, like the FIDIC form, they actually allows the contractor to claim for cost, not only time. And for some of the force majeure event clauses, they allow the party to terminate after prolonged suspension. Is that the consequence that you want to occur? You may want to think twice. So, if you are impacted by COVID-19 event and you have sought the release under the measures rolled out by the government, so for example, COVID-19 Temporary Measure Act, must you also submit claims for extension of time? Must you still submit claims for disruption and or prolongation? Is it not reasonably foreseeable by an experienced contractor at the time of submission of tender? Must you issue your force majeure notice? Must you make changes to the notice requirement under the contract for service of document? For example, under the SOP Act, your subcontractor may be submitting payment claim to you, but with the closure of workplace, be it your HQ or worksite, would those payment claims be left unattended to? Must you actually change the mode of communication? Because timing is very, very important. A review of contract is required so that you know what are the reliefs that can be sought, so that you are better equipped for the new business environment after the circuit breaker measure ends. and post-COVID-19. That's all for my session today, my sharing today. I'll hand over the time to Jeffrey. Thank you.
Thank you, Mr. Sim. It's definitely an interesting review of the COVID-19 and the possible means of contractual relief. Next, I would like to invite Mr. Ho to speak on the new COVID-19 Temporary Measures Act 2020. Mr. Ho, please.
Right. Hi. Good afternoon, everyone. Thank you for taking a time off to attend this webinar. I think by now you probably would have been inundated with all sorts of emails from all the law firms telling you all about COVID-19 force majeure and the COVID-19 Temporary Measures Act. So for the purposes of this webinar, I would assume that you would know at least something about this act. So what I'll do for the next 20 minutes or so is to just let you have a summary of how the act can actually help Singapore companies in the infrastructure space and how one goes about activating the protection that one can get under the act itself. Now, what this webinar doesn't seek to do is to go into the intricacies and details of how you actually apply for protection. So we just cover it on a broad brush basis at this point in time. Okay, now this is a snapshot of what I intend to present today. There are, as you probably know, two ways in which the COVID-19 Temporary Measures Act helps companies in Singapore. I will call it the COVID-19 Act, just as a summary. The two ways in which it does help Singapore companies is in terms of providing temporary reliefs and permanent reliefs, right? So you see the summary there. I'll talk about them in more detail later on. I will also be talking about the processes involved to invoke the protection of the COVID-19 Act. And finally, if there's time left, we will talk about some of the issues and uncertainties arising from the Act itself. Okay, two ways in which the COVID-19 Act helps companies. Okay, as I said just now, there are two ways in which the Act helps companies in this particular sector. One, by way of providing temporary relief, and the other way is to provide permanent relief. So we start with dealing with the temporary relief or temporary measures first. Now, the first type of relief, or before even I get into that, the way in which the Act provides a temporary relief is to stop a party from enforcing its legal rights against the other contracting party, which is unable to perform its obligations under a contract caused to a material extent by a COVID-19 event. Now, it seems not like a mouthful, but I think it is actually quite straightforward. First of all, you have to establish a few things. First of all, there must be an inability on one party to perform its obligations under a contract, right? And this particular inability must be caused to a material extent by a COVID-19 event. Now, I don't think we need to go too much into what is the meaning of cause to a material extent. Essentially, it just means that it's substantially caused by COVID-19 event. That means that you should be entitled to get the relief which you're seeking, provided you fulfill all the other criteria. Now, the thing which you need to pay attention to is what is a COVID-19 event. Now, COVID-19 event is actually defined in the Act itself. Essentially, it means the epidemic, the COVID-19 epidemic or the pandemic itself, plus all the other governmental actions taken to deal with the COVID-19 event. It could be, as Mr. Sim said earlier, it could be the MCOs in Malaysia, It could be the travel restrictions imposed by all the countries around the world. It could be the circuit breaker measures imposed by Singapore. So these are all COVID-19 events. So essentially, if you are able to show that you are unable to perform your obligations under a contract which is substantially caused by a COVID-19 event, then you are entitled to avail yourself of the protection of the Act itself. Now, what are these protections? Right now, don't forget. Okay, we are talking about the temporary protection at this particular point in time. Yeah, I will deal with the permanent release later on. So the temporary measures are these. First of all, no one can start or continue legal actions in suits and domestic arbitrations against a party just because it fails to perform its obligations, which inability to perform is caused by a COVID-19 event, right? And then there are other prohibitions which I have listed there, which you can read. You can't enforce any security. You can't start any insolvency proceedings. That means you cannot apply for judicial management of a particular company. You cannot apply to appoint receivers or managers. And even if you have a judgment or determination, which is essentially related to an inability to perform caused by COVID-19 event, you can't actually enforce that as well. So essentially, this is what the Act seeks to do in terms of helping the parties. Now, there's also one which I separated out right at the bottom, which is the prohibition against a call on a performance bond. Obviously, the authorities think that this is actually going to be quite a serious issue, so they devoted a particular section dealing just specifically with the issue of calling on a performance bond. So essentially, again, as I said just now, if you can show that you fit within the criteria for invoking relief under the Act, you can avail yourself of all these protections here, including the last one, which is the fact that no one can call on a performance bond which is procured by you. But there are a few important things that we need to bear in mind. Okay, first of all, okay, there is no automatic application of these temporary prohibitions, right? So a lot of clients have asked me, so what do I need to do? Do I just essentially sit around because I'm protected? The answer to that is no. If you want to avail yourself of relief under the Act, you must actually serve a notification for relief pursuant to the Act itself. Okay, how you serve it, I'll deal with it briefly later on. But essentially, once you serve this particular notice for relief, you are protected, right? And you are protected, like I said, in respect of a breach which is caused substantially by a COVID-19 event. But you have to bear something in mind. Yeah? And I'll jump straight to the last point before I come back to the other 2 points. These prohibitions only apply to an inability of February this year until the 19th of October 2020, right? That is what is called the prescribed period under the contract. So if you can show theoretically that if you are unable to perform an obligation in this prescribed period, and if you can show all the other factors, then you can file a notice for relief under the Act and get the protection of the Act. Now I'll come back to these 2 other points above. Now, do note that the temporary prohibition do not apply to statutory adjudications under the SOP Act. That is very, very important to bear in mind. Okay, so if you are the employer, or if you are the main contractor, or if you are any party which is which deals with payment claims coming in under the SOP Act, you still need to be vigilant. Okay, because you can't just say that, wow, this is a completely different the world altogether, so different rules apply. No, it doesn't. Right? You still need to watch out for those payment claims. You still need to put in your payment response in time and in accordance with the requirements of the SOP Act itself. Now, the second thing, or rather the thing which follows from there, is that temporary prohibitions do not apply to acts, to contracts rather, which are entered into after the 25th of March 2020. I think the reason is fairly obvious. And by 25th of March 2020, people would have been quite aware of what's happening around the world, and even in Singapore. And if you still go ahead and enter into contract after that particular act, it is presumed that you did it knowing full well the consequences or the potential consequences. All right, so it doesn't apply to contracts executed after 25th March 2020. Okay, now the other important point to note has to do with the prohibition on calls on performance bonds. Yeah? Now, theoretically, you or any party cannot call on the bond which is protected by a notice for relief under the Act itself. Okay, so between now, effectively, and the 19th of October 2020, you cannot call on a bond if the procurer of the bond has given a notification for relief under the Act, unless the bond itself will expire before 19th October 2020. Because otherwise, if it expires and you can't call, then obviously you'll be left out in the cold, right? So the Act actually says that if your bond expires prior to 19th October 2020, i.e. before the end of the prescribed period, you can actually call on the bond, but only within the last 7 days prior to the expiry of the bond, right? So if your bond expires sometime in June, you cannot call between now and until 7 days prior to the expiry of the bond in June itself. So I suspect what will happen is that people will try to extend the validity of the bond, which the Act also caters for. So essentially what happens is that if you extend the bond, theoretically speaking, then no calls can be made on the bond until the end of the prescribed period, which is 19th October 2020, right? Now, there is an issue with the drafting of the Act regarding this particular issue of when you can or cannot call on a particular bond towards the expiry period, and I'll deal with that in the next slide. But just bear this in mind. Now, so far I've been talking about temporary measures. So just bear in mind that these measures are temporary. So after the 19th of October 2020, these prohibitions do not apply anymore. And they do not apply unless the government decides to extend the prescribed period, which they can, and they can extend for up to another 12 months if they wanted to. Okay, but currently the prescribed period expires on 19th October 2020. Okay, let's talk about the permanent measures then. In terms of the permanent measures, as a lot of you would have heard, the permanent measures apply in this way to help people, or rather contractors or parties who are affected by the COVID-19 event. Essentially, it permanently waives any right of a party to impose liquidated damages or claim for general damages for delays caused substantially by a COVID-19 event. Okay. Now, I think you can think of it in this particular way so that it's easy to understand. You see, a lot of contracts actually provide for relief to the contractor if there is a force and a majeure event, as Mr. Sim has touched upon just now. So, in that kind of a scenario, the Act doesn't really give you any additional help. It only helps a party if the contract itself doesn't provide for any relief from the COVID-19 event. Okay, so if you look at it from the point of view of the Act actually helping parties with contract, which does not provide relief against inability to perform obligations caused substantially by COVID-19 event, that's probably easier to understand. Okay, now that's one way in which it actually helps. So it's essentially what it would do is that if you are a party which is affected by a COVID-19 event, you file a notification for relief. Theoretically speaking, you get relief from the imposition of any liquidated damages for delay as a result of your inability to perform during the prescribed period itself. Now, the second way in which the Act helps is that it provides a permanent defense to an inability to supply services or goods. So, if you are a subcontractor and are supposed to supply and install pipes, or if you're a marble supplier who is supposed to supply marble by a certain date within a prescribed period, and you can't do so because of the COVID-19 event, then your inability to do so during this event, if you qualify, then you get a permanent defense for any suit against you arising from your breach. Because don't forget, okay, your inability to do these things, to carry out your works, perform services, are still breaches under the contract. It's just that this act actually gives you relief in terms of providing you with a full defense to these breaches. Now, the few things, the few important notes to bear in mind, a few important points to note, is that, first of all, these waivers and the defense that I was talking about just now only applies in relation to delays or inability caused substantially by a COVID-19 event. Okay, it doesn't mean that you get a free pass for all the other breaches that you may have committed under the contract. So if you didn't do your works properly because you didn't design the works properly, or that your workmanship was bad, that has got nothing to do with this act at all. So an employer or main contractor can still commence legal proceedings against you in respect of these type of breaches which are not touched by the COVID-19 Act. Now, an interesting question arises as to what happens if you mix up many different causes of action. So let's say you sue a party, within that particular suit or arbitration action, there are many different causes of action, some of which are to do with COVID-19 event. What happens then? Now, that is a very interesting question, and I hope that we can talk about it during the Q&A session. Now, I also want to highlight a very important point, which is the last point on this particular slide here. Please do bear in mind that the waiver for delays is in principle only. The extent of the waiver itself is still subject to determination by the contract dispute resolution mechanism. So what do I mean by this? Essentially, if you say that I'm delayed in the performance of my works by COVID-19 event, and you apply for protection under the Act, and let's say that the employer or the main contractor disagrees with this and challenges this particular notice, this goes to an assessor who will essentially decide whether or not your claim that your inability to perform is caused by a COVID-19 event, okay, is true or not. Okay, so the assessor will decide, yes, you are unable to perform your obligations, and yes, your inability to perform is caused substantially by COVID-19 event, and that's all that he or she will decide. What the assessor would not decide is how long you were delayed. Okay, so you will not find an assessor saying that, okay, I give you 30 days extension of time, or I'll give you the whole extension of time between 1st February and 19th October. That is not the job of the assessor at all. Again, this gives rise to interesting questions, because after the 19th of October, when the prohibition stops, to sue a main contractor, or employer tries to impose LDs on the main contractor for delays, and the main contractor says that, wait, hang on a second, I got relief from the Act, and the assessor has determined that I was affected substantially by COVID-19 event, and I get this protection under the Act itself, right? So essentially, what happens in that particular case? Again, that is a very interesting question, because the assessor doesn't actually decide how many days of EOT that you get. Now, let me just move on quickly to the next few points, because I'm told that I'm running out of time. Let me just go through this quickly. Yeah. Now, the processes involved to invoke the protection of the Act itself, you can see, you have to serve a notification for relief, and if the party that you serve it on doesn't agree with it, he can actually challenge it by applying to assessor. And following from that, you have to note certain points about the assessment procedure. Assessment timelines are very aggressive. That means that you've got to be fully prepared when you actually put in a notification for relief itself. Otherwise, you will not be able to do a proper job before the assessors. Okay, so the rest of it, as I said, I don't intend to deal too much with the mechanics of the application to seek protection for yourself. Perhaps we can discuss that during the Q&A session, and especially some of these issues which I've highlighted at the back as well. Okay, Jeffrey, am I quite a bit over the time allocated?
It's okay. Thank you, Mr. Ho. Your presentation on the new act is definitely very enlightening. So before we proceed on to the panel discussion, we will be launching a short poll for the attendees. So for the attendees, this poll will run for 15 minutes and we will discuss the results right before we end the webinar. So we are going to proceed on to the third segment of today's webinar. Just before we start on that, I'll just like to inform the attendees again that please, you can ask your questions in the Q&A and we will take the questions during this segment. So I'd like to kick off the panel discussion by asking Mr. Pek a few questions. Mr. Pek, what are the disruptions the industry has faced recently, especially in relation to supply chain and labor?
Well, thanks, Jeffrey. Thanks, Chee Siong and Chien for the enlightening view of the various change of the law. Now, I think many people would have already know all the impact to the industry. I think before the circuit breaker, most of us would have experienced the disruption of material delivery, in particular the Malaysian lockdown. I think that one gives a lot of impact to Singapore companies. The Chinese that close their border, it does impact us, but maybe the effect is not as much as the Malaysians lockdown of the border. So that is in respect to the material impact before the circuit breaker. Now, as far as the manpower impact, before the circuit breaker, probably a lot of work are still moving on quite smoothly, I would say. Then the impact will be then was the company able to bring in the new foreign workers from the various countries because of the closing of the border and so on and so forth. So I would say that before the circuit breaker, perhaps the real impact to the company's construction industry here is not that great. But as we go into the circuit breaker, I think there are a lot more issues that would have been surfaced by now. And what is going to be going forward, I think is a good big question mark. Whether or not we can actually foresee them in totality, I'm not sure. But perhaps I just share a few points. I think firstly, in terms of the manpower impact, I think it will be very, very good. Now, firstly, if we were to look at the Singapore situation, currently, as you see, most of the COVID cases are from the dormitory. Now, as of today, I think we still register something like 500 over cases, although the number is coming down. And if you look at this number, will the number quickly go down to a single digit number in next 2 cycles? As we always say that this COVID, you go in a cycle of 14 days, right? And this is 500 over number. Now, you have 2 more cycles before the lifting of circuit breaker, if there is no extension. Now, there will be, I mean, by the end of May, after the 2 cycle, are we in the position to really lift all the so-called isolation of all the dormitory? If we are not able to do that, then you will see that perhaps the number of workers that is available to work will be drastically reduced. Now, secondly, even after the lifting of circuit breaker, what will be the policy direction or regulation in so-called relation to this further cases of positive COVID cases. Well, that means that maybe by the end of May, 1st June, assuming all the dormitory will be lifted, all workers can come out. Assuming there is another outbreak, which probably you will expect that there may be a few more cases. Will the dormitory continue to have lockdown? What is the direction of the definition of the further isolation and so on? So all these are going to be affecting the manpower resources even after the circuit breaker has opened. Now, secondly, as we know, the work before the circuit breakers, the demand of the construction workers are actually on the rise. More jobs are coming on into the market. Now, we actually need additional foreign workers to come into Singapore. Singapore, to a certain extent, has banned all the so-called permit to allow any more foreign workers to come into Singapore, even maybe a month before the circuit breaker. Now, will this restriction be lifted after 1st June? Would it be so-called continue to so-called ban for the next 9 months like what New Zealand or Australia is doing? Question mark. We do not know. Now, and this is going to be affecting the construction industry a lot in terms of the available of manpower. Now, even right now, if you recall one interesting thing, that on the day of the announcement of the circuit breaker, you see the causeway jam. A lot of Malaysian workers rush back to Malaysia, pack their thing, rush back to Singapore, right? I think the government and all the company acted very fast, find accommodation for them to stay and so on and so forth. A lot of Malaysians all rush back. Now, when we announce a second circuit breaker, what do you see now? You see Malaysians are going back because there is no work for them to do. First, people thought that they can, withstand for 1 month. Now it's 2 months, nothing to do. So the Malaysian workers now are queuing to go back to Malaysia. Now, after 1st June, will the Malaysian workers be able to come back on time fast enough? Will there be another restriction that they come back here will have to be quarantined for 14 days? Really big question mark. So I think the manpower disruptions is going to be very, very severe. What is it going to be? I think nobody is going to say for sure. It all depending on how the policies work. Now, as far as the material or equipment disruptions, I think if you look at it from the angle that let's say a lot of our material actually come from Malaysia. Malaysia with the MCO, a lot of factories are still not allowed to operate. Even the factory are allowed to operate, they are only allowed to operate at 50% capacity. A lot of restriction. Again, will all the factories be able to run to their full capacity, be it because of the regulation or be it whether along the line, down the line, the supply chain are all not fully recovered? European material was not so much an issue before the COVID, before the circuit breaker. And we've seen that the European city, country are all being locked down in the past 1-2 months. Their manufacturing are also very much disrupted now. So how long would this material supply is going to come back stream onto the market? We do not know, right? So the question that perhaps we all also would like to know, hear from Chee Siong and Chien later on is, while the temporary relief is covered until 19 October, but the effect of all this disruption may be much longer than 19 October. So where do we put a stop? How do we then, able to address this so-called in this temporary relief? So I think the disruption, frankly, is very large in terms of manpower and material. Now, another disruption that I probably would like to also share and talk about is actually the financial disruption. Now, you see, Construction, be whether you are main contractor, you're a subcontractor, you're a supplier, we are all going on a progress payment. We need the work to get the progress payment to turn around, right? So that you have the money to buy material fix, and then you claim, and then you get the pay. Now, we all work perhaps January or until end of March. In April and May, most people will still get payment. You get payment for your work done in February, you get payment for your work done in March, right? In the month of April and May. And in the month of April and May, you get the relief from the government, be it whether it's the job support scheme, be it whether it's the levy rebate, and also waiver of the levy. Now, what's next coming June, July, and August? Think about this. July, you will not have any more progress payment because your March work done later will have been paid in the month of May. June, you're supposed to receive your work done in April, but April there is no work done. So think about this. In the month of June, you will not have progress payment because no work done in April and May. But when the circuit breaker lifted, right, you have to start to pay for levy. You have to start to pay for your worker salary. You have to start to pay for your staff salary, but you will have no income, right? It's just that your whole financial circle get, disrupted, momentum loss, and everything get start all over again. Now, already in the month of April and May, even with the government support, right, you are probably not able to so-called turning in positive cash flow. Now you have to factor in another 3 more months of cash flow, June, July, August, right? So that you can actually see through. So this financial disruption is actually very great, right? So I think this is something that perhaps I think the companies will have to think about it. And this is also something that perhaps conversation will have to strike out with the government on how can we help to help the company to go through this next 3 months, not just about the April and May, because you reset the whole momentum, right? You have no income, but you have a lot of costs to pay, right? So I think that financial disruption is something else that we will have to take note of, right, Jeff?
Thank you, Mr. Pek. Mr. Ho and Mr. Sim, do you have anything to add in regards to the disruptions or to what Mr. Pek has spoken about?
Not me particularly. I think Mr. Pek has covered most of the things which I think contractors are concerned about. So I don't know, Mr. Sim?
Yeah, nothing from me to add.
Okay. So Mr. Pek, just another question to you. So in this case, what do you think the companies could do at this stage?
Well, I guess as far as the manpower aspect, I really think that there is no genius answer to it. I think we still got to deal with after post CB. We still have to have a disruption of manpower. Perhaps your manpower efficiency, productivity is 50–70%, be whether because the workers are being so-called isolated, be whether the workers are so-called being tested positive, or because you cannot have the full team of people on site that your work are not productive. So I think for the next few months, company will have to really think about how to deal with your workforce. Now, in terms of financial, you probably cannot factor in 100% output. And is there any way that you can so-called look at, substituting so-called the pure manpower by something else, right? I have no answer. I mean, I'm also thinking what to do, but I have no answer. But one thing for sure is that this is going to cause delay into the projects. The delay in the projects, as what both Chien and Chee Siong has already shared. You would have the temporary relief. You probably can get your EOT, but you're not getting your cost, right? So for companies that you have to think about that because of this delay, you will have to pull up your notice. You have to start working on your EOT, so-called immediately. You have to start thinking about the extra extension of whether 2 months to 6 months, the additional cost that is going to impact on you, how you're going to deal with it.
Okay, so maybe we shall take some of the questions. So this, Mr. Sim, I think there's a question directed to you at 321 regarding the whether if the contracts, there's no force majeure, what can one do?
Yes, if there are no force majeure clause inside the contract, is there any other provision upon which you can actually seek relief? So for example, like extension of time that I mentioned earlier on, is it possible to actually frame your claim as an instruction from the employer, a request for them to actually suspend works? Is it possible to actually frame the claim as a change in law that could not have been reasonably foreseeable by an experienced contractor? All these will largely depend on the terms of the contract. Of course, Chien has actually pointed out, you can seek statutory relief. But at times like this, is it wise to pull the trigger first? Or is it a better case whereby we all come together as an industry, help out each other and survive through this crisis? Is engaging the various stakeholders more appropriate than basically seek legal relief under the legal circuit breaker, which is the COVID-19 Temporary Measure Act? Thank you. Over to you, Jeffrey.
Okay, let's take the next question. I think there's a question that's asking, we can see some relief in terms of protections from LD's cash flow and extension of time. So what can we do to rely on in terms of claiming for additional costs arising from this circuit breaker?
Okay, I can share that the question. My thoughts on those questions is that have you actually looked at the contract? As I said, there is no one size fits all. Is it possible to actually fit your claim into something that entitles you to claim for cost? If not, you go by the standard way, then basically you may only get relief for time. Have you looked into framing your claim as following the instruction from the employer? Have you looked into framing your claim as complying with regulatory obligation like circuit breaker measures? Have you looked into characterizing those claims, those changes as new law upon which there is not foreseeable by an experienced contractor at the time of the contract? I think a contractual review is important so that you can avail yourself of self-help remedy, and like what LG has said, it is important to actually survive now and basically be prepared for the new future after COVID-19.
Okay,
thank you.
Thank you. So Mr. Ho.
Just to add on to that, I think Mr. Sim is completely correct that you have to look at your contract to see whether or not there are any other reliefs which are available to you contractually, because this relief provided by the COVID-19 Temporary Measures Act is actually very limited relief, and as I said just now, we are only entitled to waiver from LD on principle, okay? Because the assessors will not determine how many days of extension of time you will get. Now, the other thing about this, which I wanted to mention just now, which I didn't have the time, is this. Now, the question, I think somebody also asked, and I read a question earlier on, should you apply or should you file your notice for relief early or late? The answer to that is that it really depends. Okay, there are a few things about this assessor process which we are still not very clear about. All we are very clear about at this particular point in time is that it's supposed to be a very simple procedure. It's supposed to be very fast, and it's supposed to be undertaken by assessors who may not necessarily be very experienced, and they are not necessarily even lawyers. I mean, even for lawyers, all they need is just 3 years of experience. So if you file a notification for relief and it is challenged, it will go before an assessor who may be very junior, who may not know very much about what is going on in the construction world. And because the hearing is supposed to be very simple, very straightforward, and not that many documentation is involved, you may not necessarily get a result that you want, or you may, because, and this is actually quite important, because once the assessor makes a determination, even if it's just in principle only, that determination binds you forever. Okay, there is no appeal from this at all. So you have to think very carefully about what you want to do in terms of filing this notification for relief. I suppose you would do so if an employer or main contractor is threatening to call on a performance bond. So I suppose the first thing you do is to rush to file the notice for relief, notification for relief, and you get that temporary protection. But there are many considerations in mind before, if you're not in that kind of scenario, before you actually file a notice. You really need to think quite hard about it.
Yes. Actually, Chien is correct that really there is expressly provided under the COVID-19 Act that there is no appeal from the assessor decision. But does it mean that it's at the end of the road? What about judicial review? But it is not easy to overcome that kind of threshold, which is very high. One needs to actually think about it in a way of actually working together as an industry. It is actually filing the notification, going by the contractual route, or resorting to semi-legal proceeding, the best way forward. Thank you.
Sorry, I think Chee Siong brought up a good point. I just wanted to add before, I think LG wants to say something as well. Now, this particular point about the notification, you see, the assessors are required under the Act to make decisions on a just and equitable basis, taking into account the ability and financial capacity of the party seeking relief. Now, that gives you a clue as to how the assessors are supposed to make their decision. It's not strictly by law. So essentially, they do it on what is the fairest to all the parties, bearing in mind their financial capacity and their ability to pay. Right? So in this sense, I suppose if you make an application to an assessor, it may be that you get a more sympathetic hearing, and you may think that, well, at least I get a decision in principle that I'm entitled to an extension of time. As to how much, I'll worry about that later on.
I just want to jump in to ask this question, which is in a way related but not related, right? As just some both of you have mentioned that this temporary relief is applicable to contract signed before 25th March, right? Now, and I think I saw one question, somebody asked whether or not there will be more contract to come in the next 1 or 2 years. Well, I mean, I do not know. If the government were to pump plan, you probably will see a bit more of government projects. But my question here is this. Now, at this point of time is a time whereby there are still so much of uncertainty, right? What is COVID-19 is going to fundamentally change the contracts? What is COVID-19 going to fundamentally change the so-called regulation on the construction site, whether or not you can have your workers have to also maintain a 1 meter's distance when they are working and so forth. Now, my question here is this. Now, if I now have a contract and I sign today, what does that mean? Does it mean that I understood all about COVID-19 and I will not enjoy any more relief anymore? And if that being the case, what that means that as any of the contractor out there, should we not sign any contract right now?
Yeah, LG, can I take your question? And that's a very interesting question, because now I'm helping a client essentially tie up an EPC and a contract for the construction of a plant. So the question I asked them is, why do you want to sign this now? Apart from tying them to a particular price, because things are changing on a day by day basis. If you hire a contractor today, you sign a contract today, right? Essentially, if you sign a contract today and tomorrow, if the government introduces new measures, what happens? Do they put in an application for an extension of time immediately? And are you affected by that immediately? The answer to that must be yes. Now, in respect of the things which are already known, I don't think they should be entitled to gain any advantage from that. So if they know about all the measures which are in place, they should have taken that into consideration when scheduling and programming their works. So, but I don't think that they can actually come in. I apologize for that. My dog is barking in the background. But I think when you sign a contract, in circumstances such as this, okay, you must be taken to have known all of what is happening, not just in Singapore but around the world as well. But because the problem is that this is very highly fluid in the situation. Things keep on changing, right? So is it even safe for you to sign a contract now when tomorrow further measures could be imposed that would restrict or make your life even more difficult as a contractor?
LG, I think the answer may lie in the allocation of risk. Who actually bear that risk? If you have gone in and undertake a project bearing that risk, then is it a case where you have already priced for such risk into the contract? And is there anything to stop you from pricing such risk into the contract?
So actually, right now we have concluded a poll 10 minutes ago, and I think one of the question that we have asked is that how much help does the COVID-19 Act 2020 provide to the infrastructure projects and contracts? So we do see that 50% of the attendees they do say that it provides some help, but there are still around 16% who feels that it provides little or no help at all. So how do you all see this? In your opinion, do you think that there could be additional add-ons to this act in the future?
Well, maybe I start the ball rolling. I think, to be fair, I think that helps. I mean, if you look at it from the government perspective, it is actually quite substantial, right? Imagine that they are paying for your so-called your worker salary. Basically, they are paying for your general worker salary by giving you the levy rebate. They waive your levy, right? So I think to that extent, I think your general workers are basically taken care of. Right? Now, what is the issue really is on the staff salary, because the staff salary are kept at 4,006. Now, today, how many people actually just have a salary of 4,006 in construction? If you go by the percentage, many of them are earning a lot higher. So because of that, when the company work out in terms of the percentage of the subsidies, right, it become relatively small. But no matter small it is an help. It's better than no helps, right? And that is whereby I say just now is that while we have this relief of salary from the government for the month of April and May, most people will probably still able to pull through majority. But what really the challenges is coming in the month of June, July, August. Now, what can we do with that? Are we expecting government to continue to help us to pay salary? I'm not sure. I'm not sure whether government will continue to do that because how about other industry? Because June, July, August is more an issue of cash flow. Now, so that is a cash flow issue that we will have to work out with the client, whether or not, how can client help out in the so-called progress payment, so to elevate the so-called relieve the so-called the companies from the cash flow perspective. I mean, same go down from the main contractor to subcontractors and then to the supplier, right? So I think the biggest issue to really look at in terms of help in the next 3 months is really the cash flow perspective.
Just to add to LG here, the COVID-19 temporary measures and the act, that doesn't really give you any money. Okay, essentially it helps in terms of preventing a contractor who is already in a difficult position from being placed under greater pressure by a main contractor or an employer tracking in court, performance bond, or imposed LDs. So that's all that it does. In terms of other financial assistance from the government, I think LG has addressed that. But what I would like to touch on is this. You see, I have another project which I'm helping the clients on. The client is a main contractor. So in this particular case, what they have done is that they've actually gone to talk to the employer after gathering substantial information from their suppliers and subcontractors as to how they are affected. For example, how many workers they have, how many Indian workers, how many Bangladeshis, how many Malaysians, how many are caught in Malaysia, how many are caught by the quarantine. And once they get all this information, they will go and talk to the employer. We'll try to get some support and help from the employer, because at the end of the day, okay, if the main contractor cannot perform, at the end of the day, it is the employer who will suffer. Your project will not get done. It will not get done in time. Suing the main contractor is the last thing that will get you what you want. Okay, so I think in this particular case, as LG has pointed out, it would be best if all parties sit down to try to work out a reasonable solution to the issues at hand, be it cash flow, or some other issues.
Yes, I actually agree with LG. The key is basically cash flow. As we all know, in the construction industry, cash flow is the bloodline of the entire industry. And in this regard, the government has been trying to help, not only from the various schemes that they have introduced, but they also have actually published some circulars upon which to look favorably upon extension of time claim, try to actually help out by giving cash advance payment to contractors. But there are challenges, there are conditions, because these are public money and they need to be safeguarded. They should be put in place such that the money are actually used wisely.
Okay, we are coming towards the end of the webinar today. So I'll just like to ask the panelists again, do you have any last words? Just to note that we actually have more than 200 participants today. So it really shows that, what we are encountering right now is very relevant to the sector.
I would just like to conclude with this. There are some issues with the drafting of the act itself, and this is not meant as a criticism of the Ministry of Law or the lawyers who drafted it. They worked under extremely tight deadlines and they did a good job of it. But because of this tight deadlines, there are some issues with it, and the government has tried to address that by issuing information notes and also regulations. So, for example, when I say that you're not supposed to call on a performance bond within the prescribed period, i.e., from now until the end, until 19th of October. That is essentially what is said by Ministry of Law. If you read the act itself, it doesn't exactly say that. So there could be some issues with that, and a few other issues, which I'm happy to discuss separately.
Yes. And actually, COVID-19 is an unprecedented event. that it really changes how business are conducted. No matter how significant is the impact cost, at the end of the day, life must go on. As an industry, as a member of the industry, we all must come together and try to actually work out to tide through this difficult time so that we are prepared to actually, we are more prepared to actually meet the new challenges after COVID-19, after the new normal. Thank you.
Well, Jeff, if I may say to sum up what I would like to say today, other than earlier point, I think as industry, perhaps we need to establish a channel to have discussions with the authorities. The reason I say this is because as the situation develops, really there will be a lot of new regulation, new requirements, new norm that is going to come in. What I think the industry should do together with the authority for whatever new norm, new requirement for the work to be executed. It is good to have a conversation to talk through to see how things can be implemented, right? Otherwise, my worry is also when everybody's busy, regulation come down, when the enforcement people come down to the ground to enforce, and you find that there are 101 new regulations to follow, and if you were to miss out one or two, and then you are being put to stop work or whatsoever, I think that will be detrimental to the industry. So I think that is some things that we have to be objectively look at it, and between the authority, the developer, the contractors, the subcontractors, we should have understanding of how do we really hold our hand together to get used to the new normal, to get used to the new requirement that you need to. People, be it whether it's workers, be it whether it's staff, and whoever, we need time to get used to the new requirements. I think that is a very important thing that I think we should look at. Because during this CB period, we see there are a lot of regulation or circular that came down that people do not have time to actually respond and able to get used to.
Thank you, Mr. Pek. So we have come to the end of our webinar today. I would like to thank our 3 panelists for spending time with us this afternoon. And I'd also like to thank our attendees today for being patient with us and for your great list of insightful questions. So for the questions that are unanswered, we will work with the panelists and we will disseminate the answered questions to the registered emails to this event. And also, if any of you would like to find out more about the SBF Infrastructure Committee and to join our interest group, please just scan the QR code on this slide. We will be holding more regular webinars in the future, and we look forward to your participation. So once again, thank you everyone. Please stay safe and healthy. Goodbye.
Thank you.
Bye-bye.